Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. Hope everyone's doing well. Happy Tuesday here at 10 o'clock, and welcome to our live stream. If you are on Facebook or on YouTube watching this episode today or this live stream today, welcome. If you're new to the channel, we want to welcome you as well. As we go through this live stream, and you have any questions, please feel free to comment, whether you're on Facebook or YouTube, and we will try and get to that towards the end of the show for any Q&A. So with that, I want to welcome everybody on the other side. Oh, by the way, I'm Rick Moscoso with Captivate 365, one of the co-hosts of the Bottled Business Sense show. And on the other side, we have Mr. Bill Bernard, who is going to speak on the subject of surrounding trust. So we're going to continue that discussion. We've talked about this many times before, but I'll let Bill get into that when we start discussing that subject matter. But want to welcome Bill to the live stream. How you doing, Bill?
Thank you. I was wondering if I was going to get an identification there of who I was going to be talking to, but Rick is here today, and he's live and well. I know that. Thank you, Rick. Yeah, hey guys, I'm glad you're with us, and happy Tuesday and good health in this troubling times that we're operating under. Today we're going to talk about myths, about living trust myths that have been going around about living trusts that you probably need to have a little bit of a handle on, and some of it will be a recap of stuff that we've talked about before, but that's just natural. It's a natural lead-in. Because we want to emphasize that living trusts distribute property according to the grantor's wishes. The grantor being the creator of the trust, also can be called the settlor. So anybody called the grantor, the settlor, or the creator is the person who actually creates the trust for the benefit of certain beneficiaries. And there's a couple principal things that we all know that a trust avoids, and so I'm going to test Rick's acumen here and ask him, Rick, can you tell us at least one of two things that a trust goes to protecting?
Well, hey, I can even come up with two, Bill.
Wow,
surprisingly enough.
Let's hear it.
Yeah, well, first of all, I think you've taught me very well that it ensures your privacy. But more importantly, it helps us to avoid probate, that ugly P word, right?
Yeah, the nightmare, the probate nightmare, as I call it. It allows for a fast, easy distribution to your beneficiaries. Why? Because a trust is a private contract. It never gets exposed to the public. When you have a will and you pass away, that will must be probated. And in order to do that, you have to file it with the court. It then becomes a matter of public record, and anybody can investigate it or look it up and find out what it's all about. So that's important. A revocable trust is called a revocable trust because it can be changed at any time during the life of the grantor. It's revocable. So you can revoke it, or you can amend it, or you can restate it. The difference being, if you amend it, it's usually something that you want to change in the trust of a minor or immaterial nature sometimes, or of a material nature, but just a very specific area. A restatement is when you have a number of different changes you want to make, and so you want to update it, you want to restate it. see an attorney for that, because that can get a little bit tricky, because the trust has to be named specifically the way it was named originally when it's restated, because if it isn't, then your trust won't be funded. So let's take myth number one, that living trusts are generally for the wealthy. That couldn't be further from the truth, because if you have something of value, that's more than $166,000, let's say, in value, which most people's homes are if they own a home, then you're going to want to generally get a living trust, because otherwise it's going to go to probate court. And living trusts are not expensive when you go to my website, and we'll talk about that in a few minutes. But you don't have to be wealthy to have a living trust, and you shouldn't rely on an accumulated wealth to have a living trust. You shouldn't use that as a benchmark. As long as you have something of value that's at least $166,000 or more, because at the $166,000 or less level, approximately, then you could do a short form probate, and it's still a probate, but it's a lot shorter, a lot more convenient, and a lot more expeditious than a full-on probate would be. Myth number two, that living trusts are only for beneficiaries and not grantors. That's a myth, because a living trust can allow for the easier handling of a grantor's estate should the grantor become incapacitated, for example. And there's something I want to be very specific about here. A living trust comes into focus when you're alive, obviously, and then passes on your assets to the beneficiaries when you pass. A power of attorney, which is part of my living trust package, a power of attorney for assets, allows someone to step in and control your estate while you're still alive, but while you're incapacitated. Once you pass, a power of attorney for assets is valueless, and the living trust controls by way of your successor trustee. However, while you're alive, living trusts can benefit grantors because they provide for very specific potential that you can exercise while you're alive. For example, you might have an LLC that's in a living trust, and while you're alive, you can manage that LLC, and you can draw out a salary from that LLC as the LLC's manager, while the living trust is still protected from probate by way of that living trust. So a living trust will provide for the passing of the units that you own of that LLC, while also allowing the grantor or creator of the trust to take advantage of that privacy and that protection from probate, while also receiving wealth from that LLC. And that's just one of several ways that you can use a living trust to benefit a grantor. So remember that living trusts are not just for your beneficiaries. You can get creative and make it for your grantors as well. The benefits apply to your grantors. And if you create an irrevocable trust, that's a whole new ball game. And if you create a protection trust, then that could really benefit the creator of the trust while he or she is alive, because the property is now owned by the trust, and it's a means to manage and accumulate wealth without having any liability attached to it. That's a whole different ball game, and we have attacked that on a different show, and we'll update that on coming shows. Anyway, myth number three, that grantors can't access funds once the funds are in the trust, once the trust is funded. Of course, that's false. If you want to use the trust primarily for your benefit, you can set it up so that everything is accessible until your death. Conversely, you can make funds inaccessible to those you don't want to have access to funds during your lifetime. There's all kinds of ways to get creative with a trust. That's why, folks, based on your circumstances, that's why you need to see an attorney. This do-it-yourself stuff is garbage. I can't emphasize that enough.
Hey,
So
Bill,
there,
let me
yeah,
ask
Rick,
you something. So
shoot.
as your estate gets more complex, and maybe you're a business owner, you own a couple of businesses. Um, for those that are relatively new or interested in setting something up like this, would the trust supersede all those business assets that you have?
Well, when you say supersede, the
Well, I mean, does it overlook? Does it cover any directives that are within an LLC or
yeah,
a C
well,
corp?
the short answer is the business entity that you develop will govern the operation of that business. When it comes to protection of your personal assets, again, that business will protect your personal assets, assuming you run the business according to legal standards. When you put that business in a trust, the trust only protects that business by way of it passing to whoever you want it to pass to upon your death. It provides for protection against probate, but it doesn't provide any extra protection for your personal assets or your business assets unless that business is placed in an irrevocable trust, at which time the irrevocable trust owns the business as opposed to you. You see, when you place a business in a revocable trust, you still own that business.
Okay.
And so you rely on the business to protect your personal assets. When you place the business in a irrevocable trust, the business protects personal assets, but then the business itself is also protected by a dual layer of protection by way of the irrevocable trust, because now the irrevocable trust owns the business. You no longer own it. So picture this. In order for that business to be sued, the trust that now owns the business would have to do something wrong. If you have a business in a revocable trust, you could still be sued if the business done something wrong because you own the business, but the business limits the recovery to the business assets, not your personal assets. Right. It gets a little complicated, but not really when you go over that with a fine-tooth comb. That's why, again, you need to see a lawyer when you do this stuff, because it's very, very logical in its sequence. And you just need to know what your goals are before you decide what kind of a trust you're going to have and even what kind of a business you're going to have. Okay?
Yep. Thanks for clarifying.
Yeah. Myth number 4, that living trusts always avoid probate entirely. Now, this kind of flies in the face of what we were saying before, but I still stand by that living trusts avoid the probate nightmare. Here's a little tweak to that. You need experienced professionals to help you with your trust, because if the assets that you want to fund your trust with are not placed in the trust and they're forgotten about, then they go through the probate process. So that's the little tweak. Now, you have what's called a pour-over will that goes with your living trust package. That includes the power of attorney for assets and the power of attorney for healthcare and that stuff. So the pour-over will is different from a standard will, a standalone will, because the pour-over will ties into and is referenced in the living trust. And how it works is, if you have, let's say you have 2 or 3 properties and you forget to put one in the trust, you pass away, your attorney or the executor of the estate can go in and petition the court to have the property you forgot about pour over into that trust by arguing that you meant to put it in the trust just like you did all your other properties, but that you simply forgot. And that can create a much shorter passage of time to get that property into the trust and avoid probate. But short of something like that, whatever assets you forget to put in your trust now become unfunded, and that requires the probate process. So it's a myth to say that living trusts always avoid probate entirely, because you might forget to put something in your trust. You might forget to fund it with a particular asset, and then you may be subject to the probate nightmare after all. And the last myth I want to talk about is the fact that creating a living trust is complicated and expensive. Well, it's complicated, but it's not complicated if you get an attorney to do it. And it's not expensive if you go to pye365.com. Yeah, this is a plug, but hey, go out there and find me an attorney who's going to provide you with his professional services, who's going to provide you with a living trust for you and your family, a power of attorney for assets for you and your wife or your family, a power of attorney for healthcare directive, a pour-over will for you and your wife, or you and your loved one, or your specific partner, a declaration of trust, all of the necessary instructions and identification by way of paragraph as to what each paragraph of the trust means, and a deed to transfer your property from your personal name into your living trust. Go find that for $15.99. And if you do, I'd go with that person, assuming you check that person out on the state bar, you check that person out on the web, his or her website, read reviews about that person on any professional websites that he or she may belong to. That's the stuff you got to do. And when you do that, the trust all of a sudden is not complicated. It may still be expensive, but it may not if you get a good price on it. And that's going to have to be negotiated between you and the lawyer. So it is a falsehood that living trusts are complicated. Certainly not if you use a lawyer. And it is a falsehood that they're expensive, because if you go to pye365.com, which is Protect Your Estate 365, you're going to find that you get everything, not just a trust, and you're going to find it's very reasonable.
There's also a whole host of educational tools and resources on there that you can certainly learn from. Bill was gracious enough to educate those that are interested in creating a trust and all the considerations around that. So go to the website, because there's a lot of learning tools on there that you can benefit from.
Yeah, thanks for that, Rick. There's two ways you can approach it. You can watch videos, very short videos to the point on various topics involving estate planning. And then you can go to a drop-down box where specific questions are asked, and you click on that question and it drops down and you get a response to your question. So feel free to do that. Now I want to just close the show by talking about getting ready to set up a living trust. Now that you've got the straight scoop here on living trusts, if you're ready to move forward and make the process go even more smoothly than it would normally go, make sure you gather the following information. Make a list of all the assets that you want to include in your living trust. Remember, if you have a 401k, if you have an insurance policy, or if you have an IRA, you can exclude those from the trust because they have their own specific beneficiaries attached to them, unless you want to name the trust as the beneficiary. Then you can put those in your living trust, because then whatever is left in those vehicles are distributed evenly to whoever you want to distribute them to as named beneficiaries in the trust. Otherwise, you have those vehicles as having specific beneficiaries themselves, and they don't need to be included in the trust. But all of your other personal assets should be gathered together so you can transfer them into the trust. Make sure you know who you would like to receive these assets upon your death. That's number 2. Number 3, make sure, this is extremely important, you name a successor trustee to step in when you and your spouse or a loved one die, because that's critical. That's the person who takes over the distribution of the estate, the administration of the estate, if you will. And make sure you have more than one successor trustee. I usually like to have at least 3. And you can always also name a company, like an insurance company or a bank or something like that if you want to. So you need to know those 3 things, and make sure that minor children who would be inheriting through the trust, that you have the option to name someone to manage those assets until they reach the age of majority. And that, of course, could be your successor trustee. So make sure you do those things in planning. To contact us at PYE365 or whatever other attorney you choose to retain. Get those things together and make sure you have those things ready. So bingo, you can fill out the asset sheet that we provide and name these things quickly. You just can fill it out online on my site, or you can print it out and email it to me. Otherwise, if you fill it out online, you fill it out, you click on it, it goes right to my mailbox, and bingo, we can get started. So I hope that's been a good refresher for you guys, and I hope you take advantage of it. I can't stress enough how important it is to have an estate plan and to provide for your loved ones efficiently and in a timely fashion without that probate nightmare. That's it, Rick.
Yeah, that's great. We've talked about this subject in the past, and for those of you who may have missed that, you can always go back to our YouTube channel or our Bottle Business Sense Show website and look at the previous episodes.
Right.
We have 6 years of resources on there that we've delivered via video, via live stream for free, and it's an incredible resource. When I look back at it, there's a ton of knowledge base that came out of Bill's head and onto the World Wide Web for all of us, as well as some various marketing topics. But go to the website and just keyword trust. There's a bunch of videos that you can go back and review. So
and by the way, when you go back and review, things change, laws get updated. When you review a particular topic, make sure you put in the keywords so you can see if we have any updates on that topic. And then you can watch both videos and get a real full blast, education about it, because things do change, and obviously you can't go back and change a video. You got to update it by making a new video and making sure that topic is current. And there's a few here and there that have happened in that way. So make sure you look at that, and you'll be good to go. I don't know what to say. Mm-hmm. Free advice it's really not. Excuse me, it's not establishing an attorney-client relationship by any means, but it's free. It's a free education that allows you to then go and determine if whatever you're being told is for you, and allows you to investigate it in more detail and apply it to your specific circumstances, because it can't be legal advice as it is now, because these videos apply generally, and we don't know what your own specific circumstances are. So take advantage of it and then use it as a stepping stool and go from there.
Yeah. If you have any questions for Bill, go ahead and reach out to him. Here's his contact information on the screen. Bill at WFBlegalconsulting.com, and of course his phone number. Or you can reach him at any of the social platforms on Facebook, Twitter, LinkedIn, or YouTube. So reach out to Bill if you have more specific questions and want to discuss your particular situation and with him privately. So reach out to him and start that. Bill, thank you again for the great education we got today about trust. And as that continues, we'll be back again in a couple weeks. I can't remember the name of the.
I think we'll be talking about husband-wife LLCs, right?
Yeah, that's it. So join us in a couple weeks. That would be Tuesday at 10 a.m., July 28th, and we're going to talk about that subject matter. So once again, Bill, thanks for your expertise. We look forward to seeing our followers again in a couple weeks.
No problem. Thank you, Rick, and thank you guys, and have a prosperous week. Take care, everybody.
All right, take care.